Amendment 2, the amendment in the name for the section of HR 4040, I'll do that just for time. At the end of the bill, it starts the following. Title 3, miscellaneous provision. Section 301.
that law enforcement will have difficulty distinguishing. Even when you have a gun that you have to pick up and push the weight of it to determine whether it's a real gun or not, I mean, that's a serious situation. And when the police department had to weigh it out, and of course, you couldn't tell the number from the toy. I mean, you expect police officers to be able to distinguish that. And I think that first and last, that's continue is the common sense of that.
Thank you, Mr. Chairman. I want to begin my remarks by applauding your efforts along with Ranking Member Starks and the staff on both sides of the aisle for bringing the underlying base bill, the bipartisan bill, before the committee today. The problems and concerns we all have with consumer safety and certainly the products that are coming out of China that we've discussed for weeks here have really brought this committee together in a bipartisan display of accommodation, and I appreciate the work being done to solve problems. And it is in that same bipartisan spirit that Mr. Thompson and I bring the following amendment to the subcommittee's attention. He has just spoken so beautifully on some of the concerns that exist in his community. Reasonable people can disagree on a host of issues under this subcommittee's jurisdiction, but ensuring a safe community and a safe marketplace for American families is not a place where we disagree. We all agree to work together on that. Yet while I focus on the regulatory detail for RAD and preventing unsafe products from reaching our shores and into our homes, it is important to ensure that our domestic manufacturers have a reason to create and distribute consumer products inside the American borders. After all, U.S. health and safety standards are the model of the industrialized and developing world. So it only stands to benefit American consumers when our own manufacturers can keep the process completely here. That's the reason that we have worked on this legislation. Previously, I introduced H.R. 2013, which was legislation designed to promote and preserve the uniform safety standard designed by the federal government in the late 1980s for pre-1898 Western-style toy guns. The 1988 standard mandated that toy guns modeled on a pre-1898 Western-style be marked with a permanent blaze orange marking to ensure that law enforcement officials, parents, and other citizens understand that these are not real. It addresses some of Mr. Butterfield's concerns about how they would be marked, and as Mr. Thomas said, with a very bright color. The standard has been uniformly supported by safety organizations, law enforcement, manufacturers, and consumer product safety experts as a real step forward for toy gun safety. Yet, once again, reasonable people disagree. Since that time, a handful of state and local governments have created standards for toy guns that do not align with the federal glazed orange marking, which in turn has created uncertainty and problems for American manufacturers. This development has put some small and mid-sized manufacturers who produce this antique-style toy gun in a difficult position of making choices, one which is dramatically cut costs in order to meet the varying standards, most notably by offshoring production or two, giving up business altogether. We all know that is not a choice that we want to see them have to make. Now, one of my constituents is such a company. It's Pierce Manufacturing in Savannah, Tennessee, and they are currently feeling the squeeze of some of these regulations in their own. The amendment that we present before the committee today, which we plan to withdraw until full consideration of the underlying legislation, strikes a balance that will prevent companies such as Paris Manufacturing from making a similar and uncomfortable decision about their future and, of course, having to close their doors and lay off their workers. And more importantly, it's the product of bipartisan work and collaboration with my colleague who shares a deep commitment to preventing gun violence in his home state and city and to promoting consumer product safety. The amendment simply requires the CPSC to adopt a new uniform standard, a standard that would take developments from state and local regulation into account before going into effect and would preempt any local or state ordinance dealing with markings for antique pre-1898 style toy guns. However, the amendment creates a limitation clause that shall not apply to any provision of state or local law enforcement prior to January 30th, 1955 or any subsequent amendments enacted thereto. Mr. Chairman, Representative Townsend, I share a commitment to advancing child safety and consumer protection. It's our hope that we will have consideration of the amendment during the full committee markup, and I don't like the balance of the time. I'd be happy to do it.
Thank you.
To the amendment related to the substitute page 4040 offered by Mr. Terry, page 18, line 8, insert.
Not a case of Thank you, Mr. Chairman. This is an issue we've been discussing with the staff for the last couple of days. And simply to describe what the amendment promises about us, a certain level of flexibility within categories. For example, we have three kids at home who seem to be doing models catalogs of our home. What we would require in the current language is with each toy in the catalog that I picked on the labels because my kids all love the labels. Here's the line that we require. This is a visual. We have a record here. We require for each toy in this ad, for example. So we have it here, and this doesn't even require the language that would go with it. In some instances, the ads would be, I'm sorry, the line label would be about half the size of the actual picture and description of the toy in these catalogs. I appreciate the suggestions and input that we've received from committee staff offering other ways to make sure that perhaps there's a single there that you can end up on what that is, that is it for that toy, and you can click on it or have different references that wouldn't maybe perhaps even take up so much space or be so intrusive. So I appreciate the input and the guidance and making sure that we can continue to discuss this. And so with that, Mr. Chairman, I understand this consent to include all these as we continue to discuss the other options. Chair, thanks.
Amendment to the amendment related to the substitute page 4040 offered by Mr. Townsend. Page 12, right 10, strike examine and express. I ask unanimous consent to consider the amendment as Mr. Chairman, let me say from the start, I plan to withdraw this amendment at the same time as I'm others who've offered that we could continue to work on this before the food committee. This amendment seeks to expand our language in the dealing with standards for durable infant and toddler products by establishing an infant and toddler product review panel to assist the Commission in developing safety standards for durable infant and toddler products. This panel will be comprised of representatives of the juvenile product manufacturers industry, consumer groups, independent child product engineers and experts, and Consumer Product Safety Commission engineers. Currently, Section 104A of H.R. 4040 instructs the Consumer Product Safety Commission to examine voluntary safety standards for durable infant or toddler products and to promulgate rules that are, quote, substantially the same as the voluntary standards, but that are more stringent than the voluntary standards if the Commission determines that more stringent standards will further reduce the risk of injury associated with it. This is a strong improvement from the status quo, and I was pleased that H.R. 1698, the Infant and Toddler Durable Product Safety Act, which I had introduced, was used as the basis of this section. However, I believe this provision could be strengthened further. Most consumers will be shocked to learn that safety standards and requirements for products such as food and non-full-size goods, toddler beds, car seats, high chairs, picture chairs, hookup chairs, bath seats, gates, playouts, stationary activity centers, child carriers, strollers, rockers, swings, bassinets, and cradles are not set by the Consumer Product Safety Commission, but are set voluntarily by manufacturers who make the products. By including toddler product review panel to advise the Commission regarding the promulgation of Consumer Product Safety standards under this section, we are taking another step to make sure that the fox is no longer guiding the vendors. These products are used by the most vulnerable members of our society, our children, and they deserve nothing less. Mr. Chairman, I understand that due to the limited time we have to review the manager's amendment and prepare this amendment, more time is needed to work with committee staff to arrive at compromise on this language. I am prepared, as I said, to withdraw this amendment at this time if I can get your commitment to work with me to ensure that adequate consumer input is included in this section.
The gentleman should work.
Thank you, and with that, I ask unanimous consent to withdraw my amendment and now back to the rest of my time.
I am unanimous consent. Is that you? Situation. What purpose is that? General in Massachusetts situation. The clerk will report that way.
Amendment to the amendment in nature to substitute H.R. 44 enacted by Mr. Markey.
I understand that the same as the chair recognized from Massachusetts for violence and support this amendment. Thank you, Mr. Chairman, very much. And thank you very much. This one, I would like to use this time at this point to explain what my goal is and to prepare the community to make that full plan for the debate at that time. My amendment is simply the public right to know about the Consumer Product Safety Commission. And so the essence of this document is that back in 2000 and 2003, the CPSC documented cases of children suffering intestinal injuries after swallowing small and powerful magnets from toys. The public didn't know. The CPSC did know. And so then along goes this whole series of events here where in this one particular area, there's information that the public does not have access to. Finally, in December, CPSC recommended that magnet packs be done, but it wasn't. And it wasn't until April of 2007 that CPSC issued a recall that included all of the dangerous magnet packs products that were causing has millions of retail stores filled with coated with chemicals that create into the vapor that ingested could be flawed designs and lead to radiation impact. Actually, monitoring that toxic chemicals that often cause death. In all these cases, we hear the same story. The CPSC doesn't have the resources to investigate engineering complaints that make mistakes. In fact, according to the Chicago Tribune, of the 360,000 reports that filed in 2005 for hospital emergency rooms, not just from concerned parents filing a hotline, the CPSC selected less than 1% for a more detailed review. When the CPSC does decide to conduct an investigation, it takes time as it should. And when the CPSC wants to issue public warnings about the results of the investigation, it must first give the manufacturer 30 days to review the text of the warning, and the manufacturer can even sue the CPSC for the vendor that issued it in the first place. Now, I realize that this bill does increase resources for the CPSC to enable it to investigate more complaints. And I also realize that this bill does allow CPSC more leeway in issuing information related to public health and safety. But the fundamental problem with even these changes is that the people buying these products for their children, starving households, should not have to wait months or years to find out if someone was dying of a serious condition. Right now, the only product information one can find on the CPSC website is information about products that CPSC has been able to investigate and get manufacturer's approval to release. Information that does not identify their specific products, thousands of products, and is therefore of no real use to consumers. Why do we know this is going to work? The reason we know it's going to work is because two other agencies under the jurisdiction of this committee already provide background information. NHTSA's website is available and can be searched in order to find out complaints about any vehicles. And there's actually a form which you can just go to online, punch in, and find information about complaints which have been made. It's called defects and reclaims. Search for complaints. Here it is on the NHTSA hotline. And that's all I'm asking for with regard to the product safety committee. Similarly, another agency also within the jurisdiction of this committee, the FDA, they have a similar website where you can go. And as a consumer, as a parent, you're concerned about the impact a drug might have on anyone in the family. And can find out if there are any complaints about it. So put them on so that you can ask the physician some additional questions. That's what we're looking for from the CPSC. It's fundamental to consumer protection, but not the information. The huge support but at this time, very far to its heart. The members on those who are in favor of it in time for our farm.
I want to thank the gentleman for his amendment. I think one of the principles that we have if we want to protect consumers is to empower them as much as we can to find out information for themselves. Sometimes that's no substitute for regulation, but often it is. That is, people are, rather than having to seek a remedy from a government agency, are able to find out information for themselves before they make a decision about purchasing. And the fact that this database would not include any of the private power, but it would deal with death or risk of serious injury or death, then I think we're talking about a limited number of potentially very hazardous situations that could be prevented because this information is available to consumers. As you said, we do that with the FDA, with the National Highway Transportation Safety Administration, where people can get this information. So I think this is yet another tool that the consumer
yourself in order to make sure that injuries or death do not happen. And so I hope that between now and the community markup that we will very seriously consider and hopefully will have a bipartisan consensus that this is a fully reasonable tool as we redesign the Consumer Product Safety Commission to do a better job. So I thank the gentleman for offering this amendment and hope to work with him and the community to make sure that it is part of the next manager's amendment for committee. And I know that. This is John for the Massachusetts State Congress. At this point, I'm going to take a break and fresh air. Chairman, report the amendment. Amendment to the amendment needs a subsidy to retail 44 evidence to purchase. Page 21. The amendment is considered the chair now recognizes the gentleman from Texas for 5 minutes in support of the amendment. Mr. Chairman, I was going to reserve my chance for you to touch on very close to the amendment. But in the interest of time, it isn't going to work. I want to thank you, Mr. Chairman, and all of the council. I have an amendment that brings to increased awareness and education to retailers of second-hand products about consumer product recalls. We both for the rest improve the United States Consumer Product Safety Commission's ability to notify consumers and sellers about dangerous products more quickly and on a broader scope. During the hearing earlier this year, the CEO of the club made me wonder about what some nonprofits in my district operate with second-hand retail stores, how they were informed. I wondered if they know about the recalls, and if so, have they learned about them, and if not, what can we do in Congress to increase their awareness? After discussing this issue with a valuable and hardworking nonprofit in my district in Dayton County, Texas Community Action, I became very concerned that there may be a large group of people and associations that are not receiving information about product recalls in a timely manner. As we all know, products are recalled because they have been found to have some element of danger, some element of danger to the consumer, and they need to be immediately discarded. Nonprofits like the Salvation Army, Goodwill, and Christian Community Action, and even smaller nonprofits have serve a very specialized segment of the community and provide many invaluable resources to our communities. Often these nonprofits run second-hand retail shops to additionally help some of the neediest members of society. But I've been informed by some of the nonprofits in my district that through no fault of their own, they are unaware of the many retailers, and therefore the fear is that they may inadvertently sell recalled products to families and individuals. This gap must be closed, and this amendment will help us close it. Mr. Chairman, I realize and thank the committee for listening to my concerns, Mr. Kowski's concerns, in previous hearings, and for including a section of the bill which directs the Commission to report back to Congress with a report on how they would reach what are called informal sellers regarding resale of recalled products. I commend the committee's efforts in this section. However, I think we could even add a little bit more clarification. We think that the Commission needs additional congressional direction and congressional interest in regards to second-hand retail stores. This is especially true by the Section 2 of the bill, which prohibits the sale of recalled products. Our amendment would read as the report shall include the efforts of the Commission to reach and educate retailers of second-hand products and informal sellers, such as thrifty shops and yard sales, concerning the consumer product safety standards and food recalls, especially related to durable nursery products, in order to prevent the resale of any products that have been recalled, including the educational materials for distribution no later than 1 year after the date of enactment. Close quote. This amendment makes it absolutely clear that the Commission must educate second-hand retailers, like the ones in my district, and provide educational materials about the recalls. This amendment will help make our second-hand retail shops safer, thereby making our communities safer. I thank the chairman and ranking member, as well as the U.S. Consumer Product Safety Commission for their support of this amendment. And I do ask the rest of the committee to support the amendment. The chair. The chair will accept it.
Thank you. I just wanted to underscore how important this amendment is and how it really does fill a gap that needs to be filled. And I want to thank the chairman and ranking member for recognizing it and accepting Dr. Burgess' amendment. And thank Dr. Burgess and friend and colleague for working so diligently on this issue. Who shops at secondhand stores? Well, obviously, it's anybody who's looking for a bargain. It's often people who have less money than others, but not always. As a grandmother who has children and grandchildren who may sleep over to a play over at my house, I'll go to a secondhand store and see what kind of bargains they have for those visits. If someone's having a visitor for a weekend with a child or others, they'll be able to go purchase something at a secondhand store. Or other caregivers may go to a secondhand store. And often these are not individuals who are regularly buying these kinds of products. We don't expect them to check the CPS's website or scour the newspaper for product recalls. And so this amendment is very, very important. The fact that it now includes retailers of second-hand products in the CPS's efforts to raise awareness of consumer product safety standards in further sellers and retailers. The instructions to the CPSC to develop educational materials for distribution to retailers of second-hand consumer products is very important so that all consumers, including those who rely on their local thrift store to buy things for their children, are informed of potential hazards. So I very much appreciate the fact that this is going part of the legislation. Again, I thank Dr. Burgess for making sure that they are back. Substitute HR 4040 by Mr. Bridges, Texas. So right after section 210, the following section.
Objection to the amendment. Chair recognizes the chairman of the Texas Environment in support of this amendment. Thank you, Chairman. This year, at least 3 subcommittees of our full committee, the Energy and Climate Committee, have seriously investigated the issues of import safety. It's been an important topic in this subcommittee, the Health Subcommittee, and the Oversight and Investigation Subcommittee. And I'm a member of all 3 subcommittees. It was in the Oversight and Investigation Subcommittee during this summer that I originally learned that the Food and Drug Administration lacks the specific authority for their agency to embargo a specific food from a specific country if there were repeated instances of that food being found contaminated when it arrived in the United States. There had been a proposal in 1999 that would have given the Food and Drug Administration authority, but Congress did not accept the recommendation then, and the situation with some imported foods from some countries has only gotten worse. So I introduced H.R. 3967, the Imported Food Safety Improvement Act of 2007, to address this situation. At our subcommittee's legislative hearing on November 6th, I asked her if she had similar authority to designed to stop countries from shipping harmful food and consumer products to the United States. My amendment would allow us to take control of consumer products that are being sent to America. And I think that like this, if the goods are coming into this country on a giant conveyor belt, and we find a bad apple or a bad toy on that belt, maybe a lead contaminated toy, maybe a toy that's held together with Rohypnol that Rayburn controlled, the federal government needs to be able to push a big red button and immediately stop that from continuing into the line of commerce. This amendment would give the federal government that red button to push. The idea is simple. If either the legislation introduced 3967 or this amendment were enacted, then the Food and Drug Administration and the Consumer Product Safety Commission would have the exclusive authority to embargo a specific food or consumer product from a specific country if there were repeated instances of that type of food or product having been contaminated. I believe in this idea, and I believe that this idea would give the Consumer Product Safety Commission the tools they need to better protect Americans from dangerous products being sent from overseas. I do realize the authority would be new and would require much consultation with both the Department of Homeland Security and the United States Trade Representative Office. But Mr. Chairman, we heard from the CEO of Mattel Corporation when the discussion of lead contaminated toys came up that the toys were simply accumulating in warehouses around the country. We really have no good idea or plan as to how these are going to be dispensed or disposed of. They can't be burned because the lead goes into the air and will breathe it. They can't be burned in landfill because the lead goes into the groundwater and will break it. What we need to do is to be able to stop these products if we identify a problem. And certainly no more need to come into this country. Because of the difficulties with disposal, and Mr. Chairman, I still worry about the diversion of those contaminated products to other resellers. There are ways that they could find their way into the stream of commerce in this country or some other country, and again, exposing children to a very dangerous product. I'm committed to this idea. I'm committed to working with these other agencies to formulate a soundproof, foolproof amendment that would give the Consumer Product Safety Commission this much-needed authority. Because of the other issues that I alluded to, the U.S. Trade Representative and the Department of Homeland Security, I don't know that this amendment is quite ready for enactment, so I wanted to introduce it today to make the committee aware of how strongly I feel about the issue. I'm going to continue to work this with the other agencies and see if we can come to some agreement or resolution on some of the trade issues. But I do believe this is an idea that not only is Congress passed to, promise I can't turn on the television at night without hearing something about a recall product that has found its way to the stream of commerce in this country. That's bad enough when it happens. We don't need any more of that product accumulating on our side of the ocean. I'm going to withdraw my amendment today, Mr. Chairman, with the understanding that I will continue to work with the committee and the appropriate federal agencies and probably re-offer this amendment to Subcommittee Markup, and I'll get back to it.
Chair, thanks for joining me. For withdrawing the amendment. The amendment wants to be aware that the amendment needs to be subject to actual legislation. So, as a matter of course, I'm going to the Russian government amendment. Favors the item. I'm posting on Friday. I asked a video and I said that the amendment is agreed to. The video amendment is to be recommended. Saying that the person on Thursday forwarded the bill as amended to the full committee. All in favor say aye. All opposed say no. I ask you to comment on whatever you report is forwarded to the full committee. Without objection, the staff is authorized to make technical and performance changes to the bill consistent with the actions taken by the Subcommittee on the bills today.